In Ghana, a rare privilege exists within the public service. When a justice of the High Court, Court of Appeal, or the Supreme Court attains the age of 60 and seeks to retire, they may be entitled to a pension equal to their full salary. Two conditions must be met. They must have served for 10 continuous years at that level, or they must have served at least 20 years in the public service, with at least 5 continuous years at that qualifying level. In effect, where either of these conditions are met, they retire on their full salary. And Article 155 of the Constitution guarantees this. Now, these benefits also extend to members of the legal service, public servants employed at the Attorney General's Department. The Legal Service Act mandates that the salaries and benefits attached to posts in the service shall be equivalent to those attached to comparable posts in the judiciary. This means that an employee of the Attorney General's Department who attains the rank of Chief State Attorney or above may retire on their full salary if they have served at least 20 years in the public service or at least 5 continuous years at the qualifying level. These rules have triggered litigation in the Ghanaian courts, and in February 2026, the Supreme Court brought some clarity. Mr. Sylvester Williams began his career as an assistant legal officer at the erstwhile Post and Telecommunications Corporation, PNT, in September 1989. In 1995, the telecommunications arm of the organization was converted into a public company limited by shares called Ghana Telecom. He remained with Ghana Telecom and rose through the ranks to become the chief legal manager in July 2001. He left Ghana Telecom in March 2009 and joined the Attorney General's Department as a principal state attorney. 3 years later, he was promoted to chief state attorney, qualifying level. He retired in December 2018 at that rank. He was subsequently offered a 2-year extension, which he accepted, and he finally exited the service in December 2020. Upon retirement, he received his pension without interruption until April 2022, when the Controller and Accountants General Department informed him that he did not qualify to retire on his full salary and stopped the payments. The Attorney General issued an opinion supporting the Controller's position. It was argued that Mr. Williams had only served about 16 years in the public service, quite short of the 20 years required by law. Mr. Williams disagreed and commenced an action at the Supreme Court representing himself. He argued that he had worked for over 31 years, far exceeding the mandatory minimum: 5 years with PNT, 14 years at Ghana Telecom, and 11 years at the Attorney General's Department. His action met stiff opposition from the state. The Attorney General's Department, his former employer, argued that the Supreme Court lacked jurisdiction because the matter was a labor dispute and should be referred to the appropriate forum. They further argued that even if the court assumed jurisdiction, the 14 years he spent at Ghana Telecom, which became Vodafone and is now Telecel, ceased to be part of the public service in June 1995, when it was incorporated as a company limited by shares. Mr. Williams admitted that GT became a limited liability company in 1995, but argued that the government of Ghana remained its only shareholder. Arguing incisively, he contended that there was no true profit motive, that the government made all the major decisions from 1995 to 2008. Before Vodafone acquired shares, the entity was, in his view, still effectively a public institution. That period, he argued, should be counted in his favor. He further argued that he had served 6 years at the rank of Chief State Attorney, and if you add the 2 years on extension, it makes 8 continuous years at that qualifying level. On that basis, he maintained that he was more than qualified to retire on his full salary. The Supreme Court assumed jurisdiction, holding that Mr. Williams, as a citizen of Ghana, was challenging the act of the Controller in denying him his benefits, which were guaranteed under the Constitution. The matter was therefore properly before the court. The central issue that would determine the case was whether Ghana Telecom ceased to be part of the public service upon its incorporation as a company limited by shares. The court held that it was beyond dispute that the telecoms division of PNT had been converted into a limited liability company. This conversion changed the character of the entity from a statutory corporation into a profit-making commercial enterprise. Its purpose had become now to conduct business, make profit, and pay dividends to the shareholder, that was the government of Ghana. Under the law, a public corporation established as a commercial venture does not form part of the public service. Ghana Telecom was therefore not part of the public service. The court also held that the 2-year extension granted to Mr. Williams did not count as pensionable service for the purpose of calculating his retirement benefits. Under the legal service regulations, a person is deemed to have retired on their substantive retirement date, not at the date of any extended period. His case was therefore dismissed. The controller was justified in stopping his payments. In the end, the years he believed would secure his retirement simply did not count. What do we learn from this case? Employment in a commercialized state entity under the Companies Act does not constitute public service, even where the government is the sole shareholder. Second, one must always check the relevant laws to be sure that periods served under post-retirement extensions count towards retirement benefits. Follow Super Law GH Studios for more real stories, real cases, real people.